out of line? In a nutshell, that's what our next guest asserts about Judge Boasberg. In a recent Wall Street Journal op-ed, Dan Huff challenges the validity of US District Court Judge James Boasberg's recent deportation order.
If you recall, last month, he ordered the administration not to deport anyone in its custody under the Alien Enemies Act, a 1798 wartime law Trump invoked over what he claimed was an invasion by the Venezuelan gang Tren de Aragua. Boasberg failed, however, to apply Rule 65, which mandates that a bond be imposed to any preliminary injunction.
Here to explain exactly what this seemingly obscure rule is Dan Huff, a senior fellow at American Path Initiative. Dan previously served in the first Trump administration. Welcome, Dan.
Thank you for having me.
So I read your op-ed. I want you to explain what this measure is, but I also am curious as to if the case here is as clear-cut as you suggest, that Judge Boasberg's ruling is invalid. I'm frankly curious why the Trump administration itself hasn't pressed the case that you're making. But explain your case and then maybe answer that second point.
So the core idea is that plaintiffs who seek preliminary injunctions have to have skin in the game. The federal law provides that. Now remember, when you seek a preliminary injunction, this is pre-trial, meaning you're asking the judge to stop the government from doing something before there's been a full hearing on the merits. And that opens the door to a lot of mistakes. Now, there's a rule to address that. What happens if a mistake is made? And in the meantime, the government suffered costs in complying with this injunction that turned out later to be incorrect. Rule 65C requires plaintiffs seeking preliminary injunctions or temporary restraining orders to post bond to cover the costs and damages of the complying party in the event that the injunction is later ruled invalid. So, to bring it to this case, the Judge Boasberg, ordered the government to turn planes around, to put aliens back in custody. All these things cost money. Now, what happens if the government did have authority to deport them and instead has to bear these costs? How do they get their money back? Rule 65C says the plaintiffs who sought that injunction had to have post bond. How much is that? That can be determined, but we know what the cost of deportation flights are. We know what the cost of holding people per day is. These are public numbers. I actually ran them, and it's probably like $1 to $4 million, depending on how many and for what period of time. In this case, the judge did not order those bonds whatsoever. He didn't even really discuss it, and that is a fatal defect, because what the rule says is that an injunction can issue only if the judge requires bond. No bond was required here. Therefore, the injunction was void ab initio from the outset.
What happens if the plaintiffs don't have $1 to $4 million to post in this case? Does the judge have some discretion on how much the bond is actually worth?
So the text of the rule makes no exceptions, and neither does the legislative history. In fact, if you look back at the legislative history, Congress specifically changed the rule to switch it from being discretionary to being mandatory. So there's no basis for any sort of public interest exception. In the indigent case that you bring up, remember, the doors to the courthouse are not shut to people who cannot afford the bond. What simply happens is they have to litigate the case all the way out to its completion before getting relief. There's no initial right to a preliminary injunction. It's all pre-trial. So you just go into court, you don't ask for a preliminary injunction, you litigate your case, and if you win, you receive the benefits of that. So no one is really being shut out from the process by enforcing this rule.
And just to get back to my initial question, if it's as clear-cut as that, why is Trump's Justice Department not pressing the case?
Well, I think that good ideas, sort of fresh ideas, sometimes take time to percolate in the system. There's a tendency in Washington to simply do what's always been done. And so I think you have to see over time if it starts getting out there. And in fact, it has. So after that article came out, I've actually written several pieces on it, but the president issued a memorandum requiring agencies to seek bonds. Senator Chuck Grassley, chairman of the Senate Judiciary Committee, wrote a letter to the Attorney General, Pam Bondi, essentially asking her to press this issue harder. And in fact, if you look at the cases that have been filed, you will see that, in fact, the Justice Department has increasingly started asking for bond. So I think you're starting to see it develop. But as to why it didn't happen to start with, I think that people are very busy doing what they've always done, and no one's necessarily doing the original research, asking the fundamental questions. And so, I happen to have time to have done that, and so was pleased to be helpful.
Are there other cases where preliminary injunctions have been issued against the Trump administration that similarly did not address the bond question?
Yes, almost. I'd say half of them. In half of the cases or so, you have injunctions being set at a de minimis level, $100, or even zero. In a bunch of other cases, it hasn't even come up. So, for example, right now, you have a case pending before the Supreme Court. A district judge in California required the government to rehire 26,000 fired employees of the federal government who actually were in essentially a temporary status, a probationary status. So the government argues they could be fired. The bottom line is the judge is saying hire back these 26,000 people. That's an enormous cost. We're talking maybe $100 million a month. And in the order, the judge didn't even order a bond, didn't even discuss the bond question. It never even came up. Now, there's some permissive precedent that says, well, maybe the bond is discretionary. And as I've said, it really isn't. That's clear in the text, it's clear in the history. But even the courts that say there's some flexibility, even they say you have to at least consider it. That was not done here. The case is currently before the Supreme Court because the Justice Department has asked for a stay so that they do not have to rehire these 26,000 people. And we will see if that issue comes up in the court's consideration.
And just to be clear, because obviously, I'm not a lawyer and most of our audience won't be lawyers, I assume, is the imperative here on the judge to set the bond? Or is it just automatic? Is it the default that as the plaintiff, you have to post a bond and it is up to the judge to say what that amount should be?
It's the latter. The rule says that an injunction can issue only if there's a bond. And the amount of the bond is up to the judge, but the discretion is not uncabined. The amount has to be, under the rule, an amount adequate to cover the costs and damages that could be sustained by a wrongful injunction. But it is not the judge that is posting the bond, it is the plaintiffs, and the amount is set by the judge after considering the actual damages that could be caused.
There are some exceptions to, or at least one exception to the bond rule related to injunctions. What are those exceptions and why don't they apply in these cases?
So the one exception I believe you're referring to is that the rule itself says that the government does not have to post bond, but that is when the government is seeking an injunction. Here, the government is being sued. The rule refers to a case where the government is suing. Where the government is suing to obtain an injunction, the government does not need to post bond, but that's not at issue here. There are no other exceptions. And so it's really quite curious that none of the judges have really enforced this rule as it ought to be enforced. And it's actually very disappointing because what you have here in Judge Boasberg's case and many other cases are judges insisting on complete, precise compliance with the orders with which they issued. Right? The government is not deporting more aliens in contravention of the judge's order. It's simply, if it did anything wrong at all, it simply finished what it was already doing. So it's substantially complied. And yet the judge is saying that's not enough and I may hold you in contempt. He wants precise compliance. Well, if the judge is going to insist on precise compliance with his orders, he must precisely comply with the rules that bind him.
All right, Dan Huff, thank you so much for joining us this morning on Rising.
Thanks for having me.
Absolutely. Up next, the government is knocking on your bedroom door. Well, sort of. We'll explain next.